Form I-751, Petition to remove the conditions on residence of a foreign national spouse. When a foreign national marries a U.S. citizen, they are allowed to apply for permanent resident status in the U.S. But if the couple has been married for less than 2 years, the foreign national will be granted conditional resident status. Conditional residence, what is that all about? The U.S. Congress established the conditional residence period to combat a perception that many foreign nationals were using marriage to gain permanent residence in the U.S. At the time a foreign national obtains a conditional resident status, through admission to the United States with an immigrant visa or through adjustment of status, the USCIS will notify him or her of the conditional basis of his or her status and the requirements for removal of the conditions. Conditional residence is for 2 years. The notice should include a statement of what will happen if he or she fails to file a petition to remove the conditions. What to do when conditional residence is granted. When the foreign national spouse receives conditional residency, at the end of the conditional period, they have to verify to the U.S. that the marriage was entered into in good faith and not for immigration benefits alone, i.e., you have to prove that you did not get married to evade the immigration laws of the United States. During the 90 days before the second anniversary of the date you obtained conditional resident status, you and your spouse, if still married, must file the Form I-751, Petition to remove conditions on residence, with the USCIS for removal of conditional status. The expiration date on your alien registration card, commonly known as the green card, is the date of your second anniversary as a conditional resident. The USCIS does not send a second notice at the end of the conditional period to conditional residents to remind them to file the petition to remove conditions. Failure to file will result in the loss of your permanent resident status. If you do not apply to remove the conditions in time, your conditional resident status will be terminated and you can be removed from the country. Late filings are permitted with sufficient explanation of the reasons for being late. Once your petition is approved, you will be granted a 10-year permanent resident card. Let's take a quick look at a case here. Carrie Ann got married just over 3 years ago and received a conditional green card 23 months ago. Unfortunately, the marriage is not working out and she filed for divorce last week. She has not filed a Form 751 to remove the conditions from her residence because she and her husband were not getting along. She has lots of proof that she got married for the right reasons, because she was in love, not just to get a green card. Can she file a waiver application now? No, she can't. Because she is in divorce proceedings, she cannot file a joint petition. And since the divorce is not yet final, she doesn't qualify yet for the waiver. By her own statements, she was not abused, so she cannot seek a waiver based on that ground. Carrie Ann will have to wait for the divorce to be finalized to file. She will have a legitimate excuse, the pending divorce, for filing late, and as long as she has strong evidence of the validity of the marriage, she should be able to remove the conditions from her status. Who is eligible to apply for removal of conditional residency? You may apply to remove your conditions on permanent residence if you are still married to the same U.S. citizen or lawful permanent resident at the end of the 2-year conditional period. Your children may be included in your application if they receive their conditional resident status at the same time as you or within 90 days. You are a child and cannot be included in the petition or application of your parents for a valid reason. You are a widow or widower of a marriage that was entered into in good faith. You entered into a marriage in good faith, but the marriage was ended through divorce or annulment. You entered into a marriage in good faith, but either you or your child were battered or subject to extreme cruelty by your U.S. citizen or lawful permanent resident spouse. The termination of conditional resident status would cause extreme hardship to you. Let's look at the process for removal of conditional resident status. When the marriage is still ongoing, if you are still married to the same spouse your adjustment of status was based on, you must file during the 90 days before the second anniversary of their receiving the status of conditional resident, a joint petition with your spouse to remove the conditions on your permanent residence. The Form I-751, Petition to Remove Conditions on Residence, signed by both you and your spouse, must be submitted to the USCIS Service Center with jurisdiction over your place of residence. together with a copy of your permanent resident card and evidence of a valid marriage. The best evidence of a valid marriage is proof that you have intermingled your finances. Documents such as leases showing that you and your spouse live in the same place, documents that prove that you and your spouse own property, real or personal, together, proof of joint bank accounts, proof of credit cards in both names, insurance in both names, joint tax returns, anything like that. Another best proof that you did not get married to evade U.S. immigration laws is a birth certificate of any children born to the two of you. If you are filing when the marriage is terminated, in cases involving termination in the marriage, other than by death of the spouse, in addition to the above documents, you also need to submit copies of your divorce or annulment decree and, if applicable, evidence that you were not at fault in failing to file a petition on time. If the petitioner or applicant is a widow or widower, in addition to the above, they also need to submit their U.S. citizen spouse's death certificate. If your child received conditional residence status within 90 days of when you did, then your child may be included in your application to remove the conditions on permanent residence. Your child must file a separate application if your child received conditional residence status more than 90 days after you did. Foreign national children, stepchildren of the U.S. citizen, filing separately from their parents to remove the conditions on their permanent residence, also submit a Form I-751, petition to remove the conditions on the residence, together with a copy of their permanent resident card and a written explanation of why they are filing separately from their parents and any supporting documentation. What happens if I'm late in applying to remove the conditions on residence? If you fail to timely file the Form I-751, i.e., you don't file it within the 90-day period before your second anniversary as a conditional resident, your conditional resident status will automatically be terminated, and the USCIS will order that removal proceedings be started against you. At this point, you will receive a notice from the USCIS advising you that you failed to remove the conditions on your residence, and you will also receive a notice to appear at a deportation hearing. At the hearing, you may review and rebut the evidence against you, including filing a Form I-751 if you have a valid reason for failing to timely file. You are responsible for proving that you complied with the requirements of the law, i.e., the USCIS is not responsible for proving that you did not comply with the requirements to remove the conditions. The Form I-751 can be filed after the 90-day period. You have to submit a written statement to the Director of the Service Center to prove that there was good cause for failing to file the 751 petition on time. The Director has the discretion to approve the petition and restore your permanent resident status. How can I get a waiver of the requirement to file a joint petition? If you are unable to file or apply with your spouse to remove the conditions on your residence, you may request a waiver of the joint filing requirement. You may request consideration of more than one waiver at the same time. The I-751 has two purposes, and apart from being used as a joint petition for the immigrant and the U.S. citizen spouse or lawful permanent resident spouse, to petition for removal of the conditions, it is also used as an application for the immigrant to apply for a waiver of the requirement to file a joint petition. You may request a waiver of the joint petition requirement if, 1, you entered into your marriage in good faith and not solely to evade the U.S. immigration laws, but the marriage ended in annulment or divorce and you were not at fault in failing to file a timely petition. 2, you entered into your marriage in good faith and not solely to evade U.S. immigration laws, but during the marriage you were battered by or subjected to extreme cruelty committed by your U.S. citizen or permanent resident spouse, and you were not at fault in failing to file a joint petition. Or 3, your deportation or removal would result in extreme hardship to you. In such cases, you may apply to remove the conditions on your permanent residence any time after you become a conditional resident, but before you are removed from the country. Can I appeal an adverse decision? If your application to remove the conditions on your permanent residence is denied, you will receive a letter that must state exactly why the application was denied. Soon after your petition is denied, the USCIS will begin the process to remove you from the country. You will be allowed to have a hearing before an immigration judge who will review the denial of your application during removal proceedings. During this review, the USCIS must prove that the facts on your application were untruthful and that your application was properly denied. If the immigration judge decides to remove you from the country, you may appeal this decision to the Board of Immigration Appeals in Washington, D.C. Let's conclude here. Though marriage to a U.S. citizen gives you the privilege of acquiring permanent residence, a green card, in the United States, the USCIS does not make the process easy. Moreover, you are not granted U.S. citizenship or even permanent residence immediately after marriage to a U.S. citizen. Rather, you will be given a conditional green card for 2 years. At the end of the 2 years, you have to prove that you have a valid marriage to remove the conditions. Removal of the conditions on your permanent residence status, like the adjustment of status process, should not be assumed to be an easy process. It is estimated that each year, 450,000 Americans marry foreign nationals, and it is assumed by many that a majority marry for immigration purposes only. The authorities at the USCIS are prepared for this often abused strategy and do not grant permanent residence or citizenship to everyone who applies. The purpose of the interviewing officers at both the adjustment of status and the removal of condition stages is to ascertain the couple's true intention behind the marriage. It is the job of the married couple to prove that they did not marry solely for immigration benefits. To prove this, you have to include evidence of the relationship and show that the marriage was entered into in good faith. Proper documentation and timely filing are things that you need to take care of. Once the petition is approved, you will be granted a 10-year permanent residence card, which is certainly worth your efforts. If you have any questions about what steps you should take while filing the I-751 petition to remove conditions on permanent residence, consult a Visa Pro immigration attorney. We will be happy to guide you through this difficult process.